So today is number 2 of our 3 class sessions on on torts. Today we're going to talk about negligence. So remember that you have a quiz on this unit that's due next Monday night. That's the only, you don't have any other assignments this unit, so just a quiz next Monday night. It'll be over last Tuesday's lecture, today's lecture, Thursday's lecture, and then anything that has been assigned to you to read. Any questions on that? Everybody good with where we are? All right, so on Tuesday of last week, we talked about intentional torts. And those, of course, required, as one of the required elements of all those torts was intent. The actor, the wrongdoer, had to have intended to do whatever they did. Not necessarily intended for the consequences to happen, but they had to have intended the act. Today is a whole different classification of torts. Today we're going to talk about the tort of negligence. Negligence does not require intent at all. Okay? Negligence requires, in very broad terms, that each of us has a duty to act, to behave, to conduct ourselves, to conduct business carefully, reasonably carefully. And that if we're not careful, we're careless, and our carelessness ends up hurting someone, causing someone damages, then we could be liable for the tort of negligence. All right, so everything last week was intentional. Everything we're talking about today is unintentional. I didn't mean for the harm to happen, but my carelessness was the cause of it. So let's break that down somewhat. Negligence happens when someone's careless conduct creates a foreseeable risk of harm to others. One of the key things we're going to talk about mostly today is this element of foreseeability. All right? My carelessness might cause me to be responsible for the harm I do so long as the risk that I created was foreseeable. We've got a bunch of examples to go through that will help illustrate that. All right? If I have an accident driving down University Avenue on the way to class this morning, and it's because I'm texting while I'm driving, that could be negligence. I didn't intend to cause a wreck, but by looking at my phone, I was not carrying out my duty of driving carefully. Okay. Contrast that with I'm just driving down University Avenue and my tire explodes, and that causes me to veer into the other lane and run into Miss Hernandez. That's not negligence because I didn't have my tire blowing up was not my carelessness. Now, I could come up with a way to make that careless. Like maybe I knew my tire was low or the tread was worn. Then maybe we could color that negligent, that I have a duty to make sure my car is in good operating order, that my tires aren't worn, right? That it's foreseeable that if I drive on a damaged tire, it might blow up and I'd hit somebody. So the risk that's created by the carelessness has to be foreseeable, and it has to be something that a reasonable person would anticipate and guard against. So foreseeability is measured by this reasonable person standard. Now, if you're thinking to yourself, who is the reasonable person? Where is that defined? The reasonable person standard, if we disagree about what my duty was, reasonableness is going to be decided upon by the judge or the jury, right? If we can't agree. The jury of our peers is going to decide what a reasonable person would have done under the circumstances. So there's four basic elements of negligence. Duty of care. If we're thinking about it in terms of a lawsuit, the plaintiff is the person who's been injured, right? And the defendant was the one who was careless in the negligence scenario. All right, so to prove negligence, the plaintiff has got to show that the defendant owed a duty of care to them, that there was a breach of that duty. In other words, the defendant didn't act with the care that's expected or required. There has to be causation. The carelessness had to cause the damages or the injury. And then there's got to be damages. There has to be something that the plaintiff needs to be compensated for. Because again, tort law is about compensating the victim or the injured party for their loss. Criminal law, remember, is more interested in punishing, deterrence, that kind of thing. I could be negligent this morning. I could be walking down the hall, looking at my phone, not watching where I'm going, and I could bump into Miss Green. All right? She sues me in court for negligence. What is my duty did I have a duty of care? What's my duty when I'm walking down the hall? To watch where I'm going, right? Pay attention, not hurt anybody. Did I breach that duty when I was looking at my phone and not watching where I was going? Yep. Was that the cause of me bumping into her? Yeah. If I was looking where I was going, it wouldn't have happened. Whether she actually sues me in court is going to hinge on whether or not she has any damages. If I bump into her and knock her off balance, but she doesn't fall and she has no injuries, she's not going to be able to sue me for negligence because she doesn't have that fourth element of damages. Yes, I had a duty of care. Yes, I breached it. Yes, I caused her injury, but there's nothing to compensate her for. All right. That's where you see the contrast between civil law, tort law, and criminal law. Okay. I could bring a gun to class and shoot up the wall. All right. I haven't hurt anybody. None of y'all can sue me for any sort of negligence. But the law's still going to punish me, aren't they? Most likely. Even though I didn't hurt anyone. There's no damages. I guess CSU would say there's damages to their wall. Emotional damages, there you go. Maybe so in tort. But that would be an intentional tort. So that wouldn't be negligence, but it could be a different kind of tort. So great point. All right, remember, we're not limited. Whenever something bad happens, the good lawyers are going to look at the menu of all available things that we could sue for, and we're going to pick as many as we think could apply. So Jasper's question or comment is dead on. All right, let's break down these elements of negligence then. The duty of care. You might not know it. You might not ever have thought about it before. But hopefully now that you're learning this, when you go out into the world today, you will see or come across situations where you're like, oh, I have a duty of care here. When you get behind the wheel, I want you to think today, oh, I've got a duty of care today. If I breach this duty of care and I hurt somebody, I might be liable for the tort of negligence. Okay? We have a duty of care in anything we do. As a lawyer, I have a duty of care to represent my clients well. I've got a duty to tell them when we have court hearings, right? I've got a duty to prepare them. When you go to the doctor, the dentist, they've got a duty to treat you with the reasonable skill that that professional has. If you go to the grocery store today, those stores owe you the duty of providing a safe place to shop and conduct business. Who work? I always have people that work for or have worked for Chick-fil-A. Any of those in this class? I can't believe we don't have any. Who works in food service? Maddox, where do you work? All right. And did you have any training in your job on negligence? They might not have labeled it that, but can you think of anything that they taught you that would go to that? Okay, good. Yep, you got a duty to not cross-contaminate. You got a duty not to leave food out where it could heat to room temperature. You got a duty to clean up spills. You've got a duty to keep coffee at a temperature that's not dangerous to people, right? I mean, when you start thinking about it, almost everything you do involves a duty of care to your customers, to your coworkers, or to somebody else. Who else? Anybody else working food service? Miss Hill, Miss Mills. Okay, and same issues probably as Mr. McCrory. Can you think of a time when you were negligent? Okay, and that might be a health department regulation or something, but we do overall, we expect, and we go shop at Iron Bank Coffee, we expect that you would have, that you owe us the duty of serving us safe food, right? And where you store the eggs, I guess, has something to do with that. Anybody else think of any negligence examples in their employment? Doesn't have to be food service. Did they, just out of curiosity, did either of you in the coffee shop, did they talk about cleaning up spills or anything like that? Did you get training on that? Which is what you got to do it as soon as you can. You got to put out the do you put out the caution signs and all that stuff? Right. Okay. And that's because your employer is worried about getting sued if somebody gets hurt and you haven't fulfilled your duty of care. The duty of landowners is a little bit of a subsection here under duty of care. And we hit on that a little bit with talking about the folks at the coffee shops. But business owners must exercise reasonable care to protect their customers, their clients, from any foreseeable risks they know or should know about. All right, that's a key phrase there, should know about. If Miss Mills goes to the restroom in Iron Bank and sees that someone has spilled coffee in there, right? And then goes back to work and doesn't do anything about it, somebody else comes in and slips on it and is injured, it's not a defense for her to say, well, we didn't know about it. Okay? She should have known because she saw it. What we know about and what we should have known, if we have a disagreement about that, who decides whether we should have known or not? Say it louder. The judge or the jury, right? Because in most cases, plaintiffs are suing saying you're responsible for my injury. Most defendants are saying, no, I'm not. So we're going to have a disagreement about all the elements of negligence if we're in litigation. Landowners are generally not required to warn of dangers that are obvious and open, but you have to consider the audience when you're thinking about what your duty is to warn. So if I have a outside my business, let's say I've got a pond. Do I have a duty to warn? You think I have a duty to warn adults that they shouldn't go swimming in my pond in front of my store? Probably not, right? But for kids, that's a different story. maybe they don't understand or appreciate the risk. That's why you see a lot of warnings that seem ridiculous to you, but what they're doing is covering themselves from liability in case something goes wrong. Right? You see warnings like, on a paint can, don't eat this. Like, well, no kidding, right? But somehow somebody ate paint and probably sued the manufacturer because they didn't warn them that it was dangerous to eat it. All business, we're going to talk about this I think I'm going to save this for a later separate unit. But products liability, the safety of products, that's a whole nother category of tort. And it involves negligence. Because when you think about products liability and the manufacturing and design of products, the duty that manufacturers have is to produce safe products. They have a duty to warn us against any dangers of misuse, things like that. We'll get into that in a separate unit. I think also that we have to think, when you think about the duty to warn or the duty of landowners and things that are open and obvious, you might have clients or customers who are vision impaired or hearing impaired. And so what's open and obvious to a person who is not hearing impaired or vision impaired is going to be a lot different than what's open and obvious to a different person. So that's another reason why you see in the business world just warning everybody as much as you can. You can't go wrong over warning someone. All right. Professionals have a higher duty of care than laypersons. Meaning, if you hire me to represent you in a court case, you hire me as your lawyer, I have a higher duty of care. I have to represent you as a reasonable lawyer would, as a good lawyer would. All right. If I ask Sean to pull my tooth, okay, and he's not a dentist, his duty of care to me is a lot different than if I go to the dentist to get my tooth pulled. The dentist owes me the duty of care that a professional dentist would provide in tooth extraction. Sean only owes me the duty of a regular person if I asked somebody with no experience in tooth extraction to pull my tooth out, then he's not going to be held to the standard of a dentist. All right, does that make sense? You hire an accountant to file your taxes and they make a mistake, a careless mistake, they're held to a much higher standard than if you asked your little brother to file your taxes. Okay? All right, causation. This is a big part, this is an important element of negligence. And I want you to understand the distinction here when we talk about causation. We have causation in fact, and then we have proximate cause. Causation in fact means, would the injury have happened but for the plaintiff's actions? All right. If I drop if I run if I'm looking at my phone and I run into a telephone pole, okay, and as a result of that, the telephone pole falls over, sparks fly, a wildfire starts, it's a windy day, it spreads and ends up burning 4,000 acres, and also as a result of me hitting this pole, the power goes out in the entire Columbus metro area. All right. Is my running into the telephone pole the cause of the fire? Yes, because it wouldn't have happened but for me running into the pole. It wouldn't have happened if I hadn't done that. Is the 4,000 acres getting burned and all the homes and businesses within those 4,000 acres, is my running into the telephone pole the cause of that? Yes. Because if I hadn't hit the telephone pole, none of that would have happened. I could stretch that out pretty far down the road. Let's say that I hit the telephone pole, falls over, sparks cause a fire, winds blow the fire to burn 4,000 acres. Somebody's grandmother in Iowa finds out that their grandson's home was burned, and the grandmother in Iowa has a heart attack and dies. Is my hitting the telephone pole the actual cause of her dying? If I hadn't hit the telephone pole, the fire wouldn't have started, the home wouldn't have burned, she never would have gotten the call. So arguably it is. But I know where your mind is going with this, right? It's going to the exact place I want it to go. Actual cause and proximate cause have different meaning in the legal world. All right? Actual cause does not always result in liability. In order for the defendant to be responsible or liable, the negligence has to be the proximate cause of the injury. And we measure proximate cause by foreseeability. If it was foreseeable that my actions or my negligence caused the harm, then I'm going to be responsible legally for that. If it was not foreseeable, then I may not be legally responsible for that. So if you and I are thinking the same way, right? I knocked down the telephone pole with my car. Was it foreseeable when I hit the pole that it might fall down? Yeah, that's a foreseeable risk of running an automobile into a pole. Was it a foreseeable risk that some power might be lost? Yeah. Was it foreseeable that power would be out across the entire Chattahoochee Valley? Maybe not, right? At some point, things stop being foreseeable. Was it foreseeable that if I knocked the pole over, it might start a fire locally right there on the ground in the grass?
Potentially.
Yeah. Was it foreseeable that that would in turn burn 4,000 acres?
No.
Probably not. Was it foreseeable that if I hit this pole, it's going to start a fire that's going to burn 4,000 acres and somebody's grandmother in Iowa is going to have a heart attack when she finds out about it? That's not foreseeable. All right? So the point is, in order to have legal liability for negligence, the harm has to be foreseeable. That makes the harm the proximate cause of the injury. So actual cause, we do need actual cause for liability. I mean, I have to actually have caused an injury. But it's not enough to just have actual cause. I got to have actual cause plus proximate cause. Again, proximate cause is the question of, was it foreseeable that my carelessness would have caused that harm? All right, let's look at some examples. A delivery driver negligently drops a lit cigarette in a warehouse parking lot. The cigarette starts a small fire which travels through a vent system and sets off a hidden stockpile of explosives in a nearby factory. The explosion injures hundreds of people miles away. All right. Was the dropping the cigarette, the lit cigarette, the actual cause of the explosion? Yes, because if it wouldn't have happened but for that. Was the harm to hundreds of people far away? Is that foreseeable? Probably not. So we have actual cause but not proximate cause. And if we don't have proximate cause, we don't have what? Liability. We don't have negligence. So again, these four elements of negligence: a duty of care, a breach of the duty, causation, not just actual causation, but proximate causation, and then damages. A grocery store negligently leaves a puddle on the floor. The customer slips, hits their head, and is knocked unconscious. While waiting for help in the parking lot, the unconscious customer is struck by lightning. Was the slip the actual cause of the customer being outside? Yeah, it was. The customer slipped, hit her head, and was waiting on the ambulance.
Why would she be outside of the
Waiting on the ambulance, I guess.
while in unconscious? You should not move them.
All right, so let's unpack that for a second. Somebody's unconscious, you should not move them. Let's say that there could be some negligence in that.
Especially given a head injury.
Could be some negligence in that. Let's say that the EMTs come and put her on a stretcher, and as they're loading her in the ambulance, she's struck by lightning. That makes it a little easier. All right, we have actual cause. She would not have been on the stretcher getting loaded into the ambulance if she hadn't fell and hit her head. But proximate cause, was it foreseeable that leaving a spill puddle in the store was going to cause her to get struck by lightning? No. All right, so no liability for the lightning strike. Do we have liability for the head injury from the fall? For sure. Is it foreseeable that leaving a spill in the store would cause somebody to fall and injure themselves? Sure. We could foresee that. A restaurant negligently stores chicken at unsafe temperatures. Customer eats the chicken, contracts salmonella, and is hospitalized. Was the improper storage the cause of her getting sick? Yes, that's the actual cause. Was it the proximate cause? Yeah, it's foreseeable that if we don't store food properly, somebody could get sick from it. Salmonella is a foreseeable risk of unsafe food storage. All right. That takes us to the fourth element, which is damages. And I already mentioned to you that without injury, there really is no negligence claim because we don't have anything to recover for. Remember, in tort law, you've got compensatory damages that are designed to make the plaintiff whole, compensate them for their loss. We also have punitive damages that might be awarded in cases of gross negligence, or if the negligence was just so bad, it created such a danger that we want to punish the person for it and deter others from doing that. A court may order a trucking company to pay compensatory damages for a crash, but punitive damages if it knowingly sent out drivers who had been working unsafe hours. That might be a case where punitive damages are appropriate. Most states have what's called Good Samaritan statutes, and those protect people who offer aid who have no legal requirement to do so. So if in Slapika's example, the lady slips and falls and hits her head in Starbucks, and customers rush to her aid, and in rushing to her aid and trying to make her comfortable, they move her in a way that exacerbates her injury, and she sues them for negligence and not. The duty of care, I guess, would be to not injure her. But they did so trying to help. Most states will exempt that from negligence, saying if you give emergency aid and you don't do it right, then you're exempt from liability for that. That's a Good Samaritan statute, is what we call those.
I was going to ask, so if someone has actual cause or approximate cause, is that just when you're not going to be charged as much as if they had accident?
No. So the question is, if there's actual cause but no proximate cause, then there's no negligence. Remember, negligence requires all four elements. Sometimes we think of negligence as just the carelessness part, but negligence, the tort, requires the carelessness, the duty, the breach, the proximate cause, and the damages. So that's a great question. Defenses to negligence. All right, so let's say that you're a lawyer and you represent somebody who's being sued for negligence. There are some defenses available to you. One of them is to say that the plaintiff can't prove all four elements. Delaney just named one. A defense might be, yes, you have actual cause, but you don't have proximate cause. That'd be a defense, a possible defense. I'm not saying that's a guaranteed defense. I'm saying that's a defense you might raise. You can't just raise the defense and get out of it, right? You have to prove your defense, just like the plaintiff has to prove all elements of their claim. Assumption of risk is a defense that a defendant might use. And that happens when there is a risk. Maybe the plaintiff, maybe the defendant owed a duty of care and breached that duty. But if the plaintiff knows of the danger and is aware of it and then does it anyway, that might be assumption of risk. So let's say that Maddox is working at his coffee shop and a customer spills coffee and he does everything by the book. He ropes it off. He puts out the caution signs. He immediately goes to the back to get the mop and start cleaning it up. But while he's doing that, some customer sees it, lifts up the rope, goes under it, and then slips and falls and gets hurt. His employer might raise the defense of assumption of risk. You knew there was a spill. We warned you of it. We roped it off, and you went ahead and assumed the risk anyway. I think your outline talks about ski resort, right? They owe a duty to the skiers to warn them of the difficulty of the hills. If there's any unsafe spots, they owe a duty to rope off or mark places where you're not supposed to ski. So if they've marked an area, do not ski, and the skier does it anyway and gets hurt and they sue for negligence, then one of the defenses might be assumption of risk. You knew about it and you did it anyway. It's not my fault. And where that comes in is we have a duty of care. All right? Where that really comes in is what the defendant is saying is, I had a duty to be careful and I did my duty. I warned you. I roped it off. I put up signs. Okay? So I didn't break my duty. I didn't breach my duty. I fulfilled my duty. You're the one who was negligent. You're the one who assumed the risk. Right? So assumption of risk really negates the first two elements, the duty of care and the breach of the duty of care. Superseding cause doesn't come up all that much, but that means that something new happened, and whatever new happened, meaning after the first incident, and whatever new happened was more responsible. Let's say that in our example of the lady who slipped and fell and was put on a stretcher and is being loaded into the ambulance. A plane crashes into the store, explodes, and everybody within a mile radius dies. All right, if they were to sue the store for negligence, the store's negligence would only go up until the superseding cause came about. Once the plane crashed, that was going to happen anyway, and that's really responsible for everything else. I don't really ask you any questions about superseding cause. I think that can get a little bit confusing. But just know that's a possible defense. Something else happened after I was negligent, and whatever new happened, that was what's really responsible or more responsible. Some states, or most states, I should say all states, take into account whether or not the plaintiff was careless themselves. So some states, the reason I'm stumbling over it a little bit is states do it differently. Some states will say if the plaintiff was even a little bit careless, they can't recover at all. That's contributory negligence. That's a harsh result. Most states have comparative negligence. That's where if the plaintiff was also careless, and I'll give you an example in a minute. The plaintiff was also careless, then the jury is allowed to decide the proportion of fault that each party bears, and then they can assign the damage award accordingly. All right, so let's say that there's a spill in aisle 5 at Walmart, and Walmart knows about it. They're very slow to clean it up. They don't place markers. They don't rope it off. It takes them 2 hours to clean up. Before they clean it up, a customer slips and falls, but that customer was looking at their phone and not paying attention to where they were going. One of the defenses that Walmart might use is, hey, yes, okay, we might be negligent because we didn't clean it up right, but customer was negligent because she's got a duty to look where she's going. So then the jury's job would be to decide what percentage of fault each one was. So let's say that the lady who slips and falls incurs $100,000 of damages in medical bills. And at trial, Walmart says, well, she was also negligent. So y'all got to take that into account. The jury could decide that Walmart was 75% responsible because they'd never cleaned up their spill. But they could decide that the lady who fell was 25% responsible because she wasn't looking where she was going. So they might knock down the $100,000 in damages down to $75,000 in proportion with the fault that they assign. That's the idea of comparative negligence. Contributory negligence, in some states, that means if the lady was 25% at fault, even though Walmart was 75% at fault, she gets nothing. That's a very harsh result. Most states are comparative negligence states. I don't ask you on the quiz about that. I do want you to understand that plaintiffs may bear some responsibility under this idea of comparative and contributory negligence, that they might not recover in full. Their recovery might be reduced by the percentage that they were at fault, but I'm not going to get into really nitpicking on that. All right, the last thing in your outline is something called strict liability. And strict liability is not negligence, and it's not an intentional tort. But sometimes under the law, we hold people responsible for the damages that they caused, even when they were 100% careful. Some activities are so dangerous that what we're saying is that there's really not any degree of care that you could ever exercise that would be enough. So, for example, my warehouse stores explosives, and something sets those explosives off. Under the theory of strict liability, I still might be responsible for the damages, even though I was careful. All right, so strict liability is not negligence. It's another way of recovering. They can't use an intentional tort because I never meant for the explosives to hurt anybody. They can't use negligence because I was as careful as I could be. But some activities are so dangerous that the law says it doesn't matter how careful you are, we're still going to find you responsible. So really we skip over the duty. We don't have the 4 elements we have in negligence. We just skip right to, did this happen? Was it your property that caused it to happen? All right, well, you're just going to be responsible. If I keep a Bengal tiger as a pet in my backyard, and I have a steel cage, and I have a shock collar on, I build the best tiger cage that anybody's ever built. All right, and a tree falls and breaks my tiger cage in half. The tiger gets out and eats the neighbor's cat, and I get sued for that. Is there any intentional tort there? Did I intend for my tiger to eat the neighbor's cat? No. What about negligence? Do we have negligence? I have a duty of care in keeping the tiger, and I was as careful as I could be. It's not really my fault a tree fell on it. But under this idea of strict liability, the law might still say you didn't intend it, you were careful, you weren't negligent, but you're still responsible under strict liability. That's a very, it's uncommon that strict liability would apply, but it is a theory of recovery that's out there. All right, I want to try something new that I haven't tried before. We have 15, 20 minutes left. So what I want you to do is open up either Google or one of the AI programs. And let's search for either a current example, current events, negligence in a current events negligence case in business. Or if you work in a certain field, you could ask AI, give me an example of negligence in, I'm an employee in a coffee shop. Give me an example of negligence in my employment. Something like that. I haven't done this before, so I'm sort of making these prompts up off the top of my head. Is that giving you anything useful? Feel free to, I'm gonna get feedback in a sec. Feel free to adjust the prompt, or if you don't like what you see, to ask something else.
It's a $50 million negligence lawsuit against Starbucks for unsafe hot drink spill on a Postmates delivery driver.
All right. Hold my microphone for me. Tell me about that, Salpika.
That was just the headline.
Okay, what's the headline again?
Starbucks ordered to pay $50 million in negligence lawsuit, and it's specifically causing catastrophic burns to a delivery driver.
So Starbucks is like, so if they got dinged for $50 million verdict, does that mean this case went to trial? Yeah, this is what the jury did. All right, this is finished litigation, assuming they're not appealing. Keep going.
This has been a 5-year case.
5-year case. Finally went to trial, and Starbucks was found to be negligent. Who's got something else? Who's got one? Elrod.
This one says Georgia CVS pharmacy upheld a estimated $43 million verdict against CVS regarding a shooting in an Atlanta store parking lot. The case emphasizes the reasonably foreseeable standard for security risks, triggering new state laws to further define negligent security.
So the lawsuit was that CVS was negligent in the security that they provided in the parking lot?
And a shooting. Yeah.
Wow. So the duty of care, I'm flying generally here, the duty of care would be that landowner, business owner, has a duty to provide a safe parking lot, right? A secure parking lot. And the breach would be that they didn't somehow, sounds like there was a gunfight or something, That sounds a little bit far afield from what we would expect a business owner to have to do, right? How am I supposed to guard against gunplay in my parking lot? Any facts in there that shed light on that?
It was just a little snippet of it.
All right,
That's as far as I
good
can
one.
see.
Who's next? Good hands, T. Who's next?
You want to go?
Virginia teacher shot by first grader wins civil trial against school administrator awarded $10 million in a civil case that accused the school's former assistant principal of ignoring multiple warnings the day of the shooting.
All right, so if we break that down in negligence, right? The school's duty of care to the teachers is what? Provide a safe workplace. And part of that would be that if you know about students bringing guns to school, you need to do something about it. So the negligence would be that they had a duty to provide a safe workplace. They breached the duty when they had knowledge that students are bringing guns and they didn't do anything. Was their breach the actual cause of the teacher getting shot? Yeah. Was it the proximate cause? Meaning, is it foreseeable that if you know students are bringing guns and you don't do anything about it, somebody might get shot? Yeah. Good. Excellent one. Chappie.
This one says a cow from a fenced property on I-80 in Iowa was struck by a semi-truck, and the cow died, and the truck was damaged, and the driver was injured. And it was negligence, saying that the owner allowed the cow to travel on the highway and that his fence wasn't up to standards, I guess.
So the negligence was on the owner of the cow
That's right.
for not keeping it pinned up.
Yeah,
The cow got on the highway and that caused the accident.
caused an accident.
So is it foreseeable that if your farm's next to a highway and you don't keep your cows pinned in, they might get on the highway?
That's right.
Yeah, that's foreseeable. Good.
Yeah, I know it.
Who's next? Come over to throw it to Garcia. Good catch. Better hands than me.
So I found a Georgia jury delivered a $2.5 billion verdict against Ford in 2025 regarding a 2022 rollover crash that caused fatal asphyxiation, finding the company 85% liable for a defective roof design.
All right, I know this case. That's a great one. That happened down in Bainbridge, Georgia. So this old couple was driving a truck. They hit a culvert at high speed, flipped, and they ran off the road, hit a culvert, flipped, and the truck turned over and the cab collapsed on them. Jury found that the plaintiffs were 15% liable. Is that right? Mm-hmm. Right, because they're of some sort of careless driving or something. But they found that Ford was 85% responsible. This is a products liability case. And so it could be a form of negligence in that Ford has a duty to produce safe cars. If the design of the car was such that it wasn't safe to be rolled over, then they would have breached the duty. Then you would have causation and damages. And say that, Caleb, again, how much was that verdict for?
$2.5 billion.
$2.5 billion. That was a recent case in Georgia. And that involved products liability, but the theory was negligence, that Ford was negligent in their design and manufacture of the vehicle. All right, that's a great one. And a good example of contributory negligence. Yeah. Now, sometimes in products liability cases, plaintiffs will get together. It'll be a class action where everybody who's been injured by this sues. Like when you see on the TV, you see Camp Lejeune. Have you been in did you serve at camp? Whatever. Those are class action suits where those are the attorneys who are suing, inviting people to be part of their class of plaintiffs. All right. We got 15 minutes. Who wants to go next? These are great. Thank you, sir.
All right. I don't know how real it is, but it says
Wait a minute. You don't know how real it is.
well, no. It's Las Vegas Real Water Inc.
Okay.
They said they poisoned their customers with a toxic chemical that was used in rocket fuel.
Okay.
They said the Nevada jury issued a $3 billion punitive damage verdict against the company. They say why it was negligence too. It say the company failed to ensure product safety and falsely marketed the water as healthy.
Okay. So the duty is that they're going to serve healthy water. They apparently had some knowledge that it wasn't safe, but they went ahead and I bet that those lawyers also sued them for some sort of intentional tort of fraud or something. If they had some sort of knowledge about it, then you might cross over into an intentional tort as well. But the negligence was that they've got a duty to provide safe water. The water they provided wasn't safe. The $3 billion in punitive damages tells me that trial went very poorly for the defendant and that there was a lot of evidence that they knew what was going on, did it anyway.
It said it was a 5-year trial.
A 5-year
Trial.
a 5-year trial, or the litigation
Or
was
it went
5
for
years.
5
Yeah,
years, yeah.
that makes sense. I mean, big cases like that are going to take a while. That's a good one. Who's got the next one? Ms. Hernandez.
Don't throw in well, this happened in Georgia where I think a woman, she was pregnant back in 2016. She sued a radiologist for like negligence for like writing a confusing report because she was taking methorex, I don't know how to say that, early in the pregnancy, leading to her child's like severe birth defects. And when that happened, I guess she sued him for negligence for assigning her that because he was working with diagnostic imaging specialists at the time. So
He had a duty to provide her with good care. He should
Mhm.
have known better in his professional capacity than to prescribe her that medicine if she was pregnant,
exactly.
right? That's the negligence, that's the breach of the duty there.
Mhm.
That's a good one. All medical malpractice cases are negligence. You had a duty to operate on me right or provide me with the right medical care or prescribe me the right medicine, and you breached that when things went wrong. Those are medical malpractice cases. Good. Who's next? Pass it on down to Ms. Mills. I know these ladies have something to say.
This is a mismanagement of client assets negligence case. A Boston-based firm was involved in a $59 million malpractice case where the firm was accused of not acting quickly enough to investigate a former employee's systematic looting of funds leading up to over $10 million in losses.
All right, so the duty would be that we have to supervise our employees, right? That we have to take steps against them stealing. Now, the steps that we would have to take, the duty of care again becomes from reasonableness. Well, there's no way we can guard against everything, but we have to guard against what is foreseeable. Is it foreseeable that if we don't have certain protections in place or certain safeguards in place, an employee might be able to steal money? Yeah, that's foreseeable. Good. Mr. Weatherly, what you got?
In a Texas civil lawsuit, a Dallas County jury found that a major cable company was negligently responsible for the brutal murder of a customer by one of its field technicians because they were negligent in checking their background.
All right, that's a good one. So we expect companies to do background checks on their employees that they send to people's homes. Is that a reasonable expectation? Yeah. If you don't do that and you found out someone has a violent past that you would have hired them if you knew, that'd be a breach of that duty. And then is it foreseeable that if you hire somebody to go into people's houses that has a violent past that they might act out of violence again? That's pretty foreseeable. Yeah. And so we got the damages. Good. Ms. Green.
Mine says a Royal Caribbean passenger sues cruise line after he allegedly fell headfirst on the surf simulator and fractured his neck. The passenger was suing because he fell headfirst. It was a civil complaint because they said that the flow rider was shortened to fit the cruise boat. And so since it was shortened, it's already dangerous, and now it's even more dangerous.
I see. So they altered it in a way that made it unsafe.
Right.
Because we would expect any plaintiff who gets on it to understand the normal risks, right, of getting on the wave rider, whatever, you might fall. But we would not expect the cruise to have shortened it to a way that's then becomes dangerous.
Right.
Good, good, good. All right, you can throw it to me. Good job, everybody. No, that's fine. You can't hurt these. All right, let me read out one more example I've got. Can't turn that off. That's still. So there was a lawsuit brought against a hotel in Atlanta where a lot of sex trafficking was going on and child sex trafficking was going on. I don't think it's been settled yet. It might have been settled, but this is the complaint that I'm reading from. So to tie in what we talked about in the litigation process, remember the complaint is the document that a plaintiff files that lays out all of their allegations and why they think they should get relief. So this complaint has a count for negligence. And they are suing the parent corporation of the hotel. So these are some facts that they're laying out. At all times, the owners owed a duty to the invitees to exercise ordinary care in keeping the premises and approaches safe from criminal activity, especially minor sex trafficking. They breached its duty by failing to exercise even ordinary care to keep the premises safe and by negligently permitting criminal activity. They allowed it to exist and flourish. They knew or should have known the steps to take to prevent the inn from being used as a venue for sex trafficking. The hospitality industry is in a unique position to identify and report human trafficking due to its perceived anonymity. From check-in to check-out, there are a number of indicators victims and exploiters exhibit during the time they're on a hotel property. With proper training, a front desk agent or a housekeeper can notice that something is not right and have a duty to report that. They're saying that the company was negligent because they did not establish corporate policies and procedures against sex trafficking. They were negligent in not training employees in children's rights, prevention of sexual exploitation, and how to report cases. They knew or should have known that the Department of Homeland Security puts out guidelines on how to prevent sex trafficking. They did not implement appropriate steps such as training on those guidelines or warning signs. They had knowledge of multiple reports and arrests related to sex trafficking and other sex crimes at their hotel. And as a result, they negligently failed to implement reasonable, appropriate, adequate measures to protect its invitees from becoming victims. I'm reading through this. They had actual knowledge of the criminal activity, didn't do anything about it. Plaintiff's sex trafficking was foreseeable because it knew or should have known about the actual events that were going on at the hotel, as well as the history and other crimes at that hotel and other hotels in the area. Northbrook breached its duty by failing to exercise ordinary care to keep the premises safe and negligently permitting the criminal activity. In the exercise of ordinary care, they should have known of dangers and hazards existing on the premises. They failed to maintain, inspect, secure, patrol, manage the premises in a safe way. This doesn't mean that that's what the jury found or that's what actually happened. This is just the complaint that the plaintiff filed. The reason I wanted to read from it to you is it shows you how when you're alleging a tort, you've got to lay out the elements of it. So they're laying out the facts that show that the management had a duty to provide a safe hotel, that they breached that duty by not providing a safe hotel, by having knowledge of dangerous activity going on and not doing anything about it, by not patrolling, surveilling, doing all the things they should have done. That breach was the cause of the plaintiff being trafficked. Proximate causation would require, is it foreseeable that if we know sex trafficking is going on in our hotel, that minors might end up being sex trafficked? Yeah, that's proximate cause. And then the plaintiff who was trafficked suffered some damages. So that's how they would assert a negligence claim against the hotel under those circumstances. And that's very similar to the examples that you all read to me earlier. All right, that is the tort of negligence. Anybody have any questions about that? So for Thursday, I need you to read the 2 class scenario, what's it called? Fact pattern for class discussion. Fact pattern 1 for discussion 219, fact pattern 2 for discussion 219. I'm also going to put up a case that I'm missing, but it needs to go up. It'll be the Willingham versus Hudson case. It's a Georgia case involving negligence and the Georgia Good Samaritan statute. So I will post that here in a minute. So I need you to read the fact patterns and the case for Thursday. We'll have a good discussion on Thursday. See y'all then. If you came in late, let me know. All right, hold on. Green, Will Green, I got you. Mr. Gardner, I got you. Miss Battistini, I got you. Mr. Bernard, I got you. Mr. Eason here. Mr. Eason, I got you. Mr. Hoffa was not here. Hackett, I got you. Nixon, Mr. Nixon show. Did Mr. Price show? Spalding showed, I got you. Miss Stewart, I got you. I think that's everybody. Your name? Price. Say it again. Right. Oh, I already got you. Yeah, I'm sorry. I saw you. Let's post this case right now before I forget. Case.
I have a random question.
Yep.
So going back to like the medical malpractice part of negligence, isn't that like part of why anesthesiologists make so much? Is their risk of getting sued?
Could be that they're allowed to jack their prices up. Yeah. That I would say that is part of the pricing mechanism for folks, because what that means is the anesthesiologists are paying more for insurance, their malpractice insurance.
Yeah.
So that's getting passed along.
Okay.
That's exactly right.
Okay.
Yeah.
Makes sense.
Yeah, that would happen. I mean, some like I do that in my practice. There are some types of adoptions that I charge a lot more for because they're riskier. And I just want everybody to know this is, I'm factoring that in. But yeah, absolutely. It's a great question. Yes, ma'am.
Apologies for missing Thursday as well. I left Columbus, not this past Thursday, but Thursday prior, directly after class.
You had a funeral, right?
Yeah. So I'd stopped in Atlanta on the weekend, and then I was staying home until Tuesday, which was the day of the funeral, because I only have in-person classes on Tuesday and Thursday. Well, somewhere in the mix of things, I picked up an illness and had a fever.
Oh, no.
For like 3 days straight.
Oh, I'm sorry. Well,
so then I had to miss all my classes on Thursday.
You don't have to apologize because that happens. I totally understand it.
I hate hate missing classes, especially in a row.
I
'cause then
understand.
it's easier to fall behind.
Totally understand. No worries.
But I figure
You're good. I think you only have 2. That's all I have you for. Is that right?
it's either 2 or 3. I don't know.
I only have you for 2. No, yeah, I have you for 2. So you're good. If you got a free one along the way, you can.
I figured fever and delirious and going through an entire box of tissues did not mean coming to class.
No, I think that's reasonable.
No clue
So-
what I had. I'm fine now. Still a little stuffy, but like, eh.
My wife is sick too, so I know it's going around.
Well, you have a nice day.
All right, you too. All right, McCrory, I'm gonna try to come see y'all this weekend.
Surely we'll be able to take care of that.
I can tell. Did you tell Coach I have some eligibility?
I haven't told him that yet. I can tell.
No, I'm kidding.
We got one of our freshman pitchers back off injury. Well, he's like, I mean, he's still working his way back. Another thing is the week after